Yes, good afternoon.
Afternoon, sir.
Hi, good afternoon. Good afternoon. I think today we won't have a lot of problems, administrative problems. I think everyone is here. We know that this is where we're supposed to be. I'm just going to give it a minute or so for people to join. It's 3:01. Today we're supposed to end at 4. Is it 4 or is it 5?
It's 4.
We're supposed to end at 4.
Yes.
Hey.
Yes, it's 4.
Yes. Do you guys want us to end at 5?
4 is fine, sir.
Not as you like it, Prof.
It's fine, sir.
It's fine. We can do it until 7. I'm ready today. 7 o'clock.
Any form of knowledge is welcome, Prof.
As you like it.
Let's see what we can do between now and 4 o'clock. And if there's a lot, we'll just maybe make it until just after 4. I'm also not feeling I'm not feeling too well. Ordinarily I would have said that I'm not available today, but I thought let me try my best under the circumstances, and let's see. So we'll try. It's not a problem. I see Octavius. Do you want to speak?
Yes.
Hello.
Yes, Prof. Just to make you aware, I think it was the same thing last week. There's a link that we were given by Professor Lee, which some people are in that class. Is it possible maybe that we could share this link on my UNISA somehow so that the people can have access to it?
You know what, I'm actually quite irritated if that is the case, because it's not supposed to happen. If it happened last week, it was not supposed to happen today. There should only be one link. I don't understand why is it that many links are being sent. It's quite irritating. Are you able to perhaps send someone, can they just send an email to one of the people there just to let them know that this is where we are? Is it possible? Please do.
I will try and just inform them, but unfortunately I'm not, because I don't have access to the app, I'm not able to send a message like in the chat.
Yeah, so no, not just you. I'm saying that anyone who's able to Tandiwe, I'm listening to you.
Oh, good day, Prof.
Hi.
I was in the other group, so I managed to join through the link. Someone posted the link on the other group, so I managed to come to this group. So I think people will be able to join if they follow that link. I was in the group.
No, I hear you. I was just saying that if someone is able to send an email to some of the people who are there, so that they can also tell others who are there, you know.
Okay.
I'll appreciate that. Yes.
If I may just add something.
I'm very sorry about that. I thought that this issue is sorted.
If I may just add something. Hello? Hello? Hello?
Gabriel, I'm listening to you.
What I'm saying, the issue is, it's not that people cannot access the group. The problem is some of them are in the group as guests. As a result, they do not have the full features of Teams, and that's why they don't have access. The only way that can happen is if it is posted on my UNISA so everyone can get access to the link. Speaking of myself as well, I got the link from Prof. Stone initially after sending an email, and then she sent it to me. That's how I was able to access the group, because also I was a guest. Even on this group, I'm still a guest, but through that link. So the best way is if perhaps on your end administratively, if you can post the link onto my UNISA, then everyone will definitely have access. Until then, it's still going to continue.
Okay, let me see if I can get hold of her. Just give me a second.
All right.
Okay, I've just spoken to Professor Lee Stone, and she's sending another email to let everyone know that this is where we are. So we'll just give it a minute. In the meantime, can I just ask if anyone has read the Zuma case? All of it. Has anyone read the case? Hello, am I audible?
100% audible, Prof. Are you referring to the
Yes, the
PMB
Constitutional
one
Code case.
or the Constitutional Code?
The Constitutional Code case that we spoke about last week. Has anyone read it?
I read the judgment, but I never read the full case. I just read the initial outcome because there were certain parts that I was not sure on. But yeah, but I came to understand that from what I came to understand from Judge Hampepe was that the initial reasoning, I'm under correction, why they eventually decided to sentence him to 15 months is because outside him having been in contempt of court, it's because he kept playing the public card or the sympathy card, and having been the number one statesman, he should have been aware of the consequences. And that is why they took it upon themselves to first do the judgment. And the second part was also because they felt the politics of it, if they didn't impose a harsher sentence, would open the door to anyone else to challenge the law, so to speak, in that regard. So they had to send a message. That's what I understood from the judgment.
Right. No, that's perfect. I mean, that's great. You spot on. The advice that I would give, and thanks for that. Was it Kamel? Who was speaking now? I think it was.
Yes, it was.
Yes, Kamel. No, that's good. It's good. But to all other students here, everyone, it is quite important, if you can hear me, that you get into the habit of reading cases, because that's how you're going to understand the actual application of the law, of principles. So if we are talking about separation of powers and the judiciary, it is important that the cases that you have that have been listed, that you should read, and also you see when you are going through the prescribed book, that there are quite a number of cases that the book refers to in relation to separation of power and the judiciary. So it is quite important that you really get hold of the case. Give yourself time to go through a case, understand it from beginning to the end. Right? That's how you begin to appreciate certain concepts and how they are applied in practice. If you don't read cases, you're gonna have problems in actually understanding. You'll even forget, because all you'll be doing is to be engaging in rote learning, and just cram work of some sort. So read the cases that are prescribed, that have been said you must read, but also as you're reading the prescribed book, you will see that it makes reference to certain cases. Don't just say that you understand the part that the book has quoted. For you to understand, you have to go throughout the case, read it from beginning to end, so that you can also appreciate the facts that informs the decision of the case. Most of the times in this prescribed book, they'll tell you the decision. This is what was decided. But you need to understand the facts that informed the decision. And for you to understand the facts that inform the decision, hello? There's someone who's can someone who's not on mute themselves? Yeah, thank you. So you need to understand the facts that inform a decision. That is also how you begin to see law at work, law in action, and that makes life easier for you. I'll tell you, if you read cases, you are able to tackle any exam question with ease. Okay? Because in an exam question, the likelihood is that you'll be given a problem type question to say these are the facts and what's your understanding. If it's not a problem type question, it says discuss separation of powers. When you discuss it, you have to make reference to cases, particularly constitutional court cases that would have been decided. So I cannot emphasize it enough sufficiently that it is important to read cases that have been prescribed, and if you have time, also read other cases. What they usually assist, it's something that just as a form of advice. Sometimes it's just give yourself, say, Saturday mornings or Friday afternoons from 1 o'clock up to 5 o'clock every Friday. That's my time to just go through cases, even the latest cases, right? That's how you really begin to appreciate a number of things that make your life much easier. Right. So, having said that, we are going to continue today with separation of powers in relation to the judiciary. So, last week we dealt with separation of powers, the history of the judiciary. We dealt with the history of the judiciary, the implication and complicity of the judiciary in apartheid, in colonialism, and so forth. And I then indicated that today we will proceed with the post-apartheid judiciary in relation to separation of powers. if I can just be given a minute so that I can close the windows for me. There's noise coming from behind. If I can just be given a minute, 30 seconds more. Sorry about that, guys. So yes, so this is where we're going to start today. I'm just going to look for this quickly. Let's see. Yes. Can everyone see? Can I get a yes?
Yes.
Oh, wonderful, wonderful. Okay. So, as I indicated, that we obviously today are continuing, and I hope that you still have what we spoke about in mind. So let me do this. Okay, sorry, a sec again. Just a second. Right. Everyone can see, right? Can I just get one to say yes?
Yes.
Yeah. So, what the slides here, I have about 30 slides. Right, and the slides that I have are basically a summary of your prescribed book. So I'm following some of those who have read will recognize some of the issues or some of the quotations here, because they are directly from the book. I thought today we'll just move with the prescribed book and we can then continue to discuss it. So as you can see here, that the first slide, the first thing that we're going to be talking about is the role of courts in a constitutional democracy. The role of courts in a constitutional democracy has obviously been changed by the dawn of what we call constitutionalism in South Africa, right? If you don't also understand the concept of constitutionalism, I also would advise you to go and find out what constitutionalism means. Can anyone just maybe volunteer to tell me what is their understanding of constitutionalism? Whoever wants to speak can speak, because I can't see now. I can't see who wants to speak. I just want someone to tell me their understanding. By the way, there's no right and wrong answer here. We're discussing, as I always say to others, that this is a process wherein we are learning, and the more you speak, the more I also learn. You know, so there's nothing called a wrong answer. As long as you're able to say why you're saying something, it's good enough. Any volunteer?
Afternoon,
Yes.
sir. Can I try to answer?
Yes, please.
I think constitutionalism involves that authority that's placed in government should be found in like principles in a constitution, like in terms of rule of law, and that supremacy is found in a constitution. So the government and the authority must be found in such principles in order for a country to be placed as a constitutional state. They have to
Yes.
find their power and authority within such principles.
You are spot on. You are spot on. What you need to understand, and thank you so much for that. I think it's a very good answer. In any society today, at least, you have a government and you have the people, right? And in modern societies, you would have a constitution that regulates the relationship between government and the people, right? Now, that being the case, before I move on, you have to understand the difference between constitutionalism and a constitution. There's a difference between constitutionalism and a constitution. So there are instances where you can have a constitution without constitutionalism, meaning that in that particular constitution, certain elements that make up the notion of constitutionalism may be lacking, right? For instance, you may have a constitution that does not make provision for the separation of powers, right? You may have a constitution that does not make provision for judicial review of executive acts, right? You may have a constitution that does not limit the powers of the state. Now, so when we talk about constitutionalism, we're talking about a constitution that makes provision for, amongst others, limitation of power. Number 2, separation of power. Number 3, supremacy of the constitution. Number 4, what's the fourth one? The rule of law and so forth, right? So there's a debate. I'll give you an example, right? Let's take we can take an example of the Ethiopian constitution, wherein the final arbiter in terms of constitutional interpretation lies with a political organ. Some people may say that although Ethiopia has a constitution, it does not have constitutionalism because there isn't a judicial review. You don't have a Supreme Court that makes the final determination of what is constitutional and what is not constitutional. So it's quite important to understand that the fact that you have a constitution does not mean that you live or the system is what we call constitutionalism. So there's always a difference. So you can have a constitution without constitutionalism. So that's very important. So go and check and understand what constitutionalism is, but also bear in mind that it doesn't follow that if a country, almost every country has a constitution, but not almost every country uses constitutionalism as a system, as a form, as a theory and method of governance. Is that understood so far? Can I get a yes or a no?
Yes, sir.
Yes.
Yeah. So just
clear.
Go make a note of that and go and in your own time do a bit of reading on what constitutionalism, what are the elements of constitutionalism. But when you are doing that, what is often not told to students of constitutional law is that a constitution does not equal constitutionalism, that you can have a constitution without constitutionalism, right? But I just hope you get to understand that so that you can be able to locate what we're going to discuss within that. It's quite important that you understand that before we proceed, but I hope you have a little bit of understanding. remember what I said last week about the fact that there was a democracy, for instance, for white people during the apartheid era, right? But the question is that democracy was not for black people, it was for white people. But the other question related to that is whether was there constitutionalism during the apartheid era as we have it today? Did all the elements that make up constitutionalism exist during the apartheid era? Because remember, all apartheid governments had a constitution. There was always a constitution, at least from 1910, I think. So that's where the importance of history comes onto the fore. Right. Now, having said that, let's go to this slide and read it and say that in a constitutional democracy, the judiciary is often referred to as the bastion of the legal order, right? And this is because in a constitutional democracy with a supreme and enforceable constitution, an independent judiciary is free to interpret and apply the law impartially and without consideration of the wishes of politicians, powerful business interests, and so forth. According to this theory, the system of separation of powers and checks and balances can only operate optimally. Someone just kicked me out.
No, we can hear you, Prof.
Yes,
You can hear me.
Yes, we can hear you.
Am I still here? Okay. Can you still see the slides? Can you see the slides?
Yes, we can.
Okay.
We're still on the first slide.
Good. Okay, yes. So according to this theory, the system of separation of powers and checks and balances can only operate optimally if an independent and impartial judiciary. If an independent judiciary is empowered to enforce the provisions of the Constitution, right? Now, in a constitutional democracy, I would call it in constitutionalism, the judiciary acts as a referee for the democratic process while also checking whether the two political branches of government, that is the legislature and the executive, act within the boundaries set up. Right. Now, the essence of this is that in a constitutional democracy, the role of courts are to act as independent and impartial referee. In a constitutional democracy, courts are supposed to check whether the two political branches of government are acting within the boundaries set out by the Constitution and by legislation, right? So understand the role of a court or of courts in a constitutional democracy. And when you understand it within the context of the Constitution. Right. Now, the reason why I was asking if you've read the case of Zuma last week, that is the Secretary of the Judicial Commission versus Jacob Zuma, wherein Mr. Zuma, Jacob Zuma, was convicted of the crime of contempt. The reason why I said you should read that case is that if you read the very first sentence, the introduction, wherein the judge says that it is indeed the lofty and lonely work of the judiciary, impervious to public commentary and political rhetoric, to uphold, protect, and apply the Constitution and the law at any cost. So here, Justice Khampembe is saying that fundamental to the role of the judiciary in a constitutional democracy is to ensure that the Constitution is protected at all costs, to uphold the Constitution. So, role of the Constitution in a constitutional, role of courts in a constitutional democracy is to fundamentally ensure that the Constitution and the law are protected and upheld at all costs, right? That is what the judgment is saying, and that is generally the expectation of courts in a constitutional democracy. And the reason being that, remember that the Constitution is the supreme law of the country. All law that are in contravention at variance with the Constitution are unconstitutional, are invalid, because the Constitution is the supreme law of the country. We know that, you know that by now. So the role of the courts is to make sure that the Constitution, including the laws, including anyone, how they behave and so forth, they adhere to fundamentally the Constitution. That is the role of courts in a constitutional democracy. May I also say at this point that you should also go to the Constitution, have a Constitution, and read sections that deal with judicial authority. And it's quite simple. The Constitution is written in very simple language. So go and read that and understand what the role of courts is, particularly in terms of the Constitution, right? So in the case of the economic freedom fighters and others, it was held that the majority of the court, it was held by the majority of the court that the court has a duty to uphold the Constitution even when this required it to intervene in powers exercised by the legislature. Right. Now, here we're beginning to talk about separation. And what this case, the economic freedom fighters case and others, if you go into the your prescribed book, there's a citation there, so that you can be able to access the case. If you want to access the case, it's very simple. Just go to the Constitutional Code website and check it, or go to SAFLI and check it. Right, you see that it is there. So the Constitutional Code here is saying that even where, or in instances where it is clear that, before I even say that, you must understand the notion of separation of powers, right? And the essence of separation of powers is that if I'm the judiciary, I must not interfere with the executive. If I'm the executive, I must not interfere in the work or competence or functions of courts. If I am the legislature, I must not interfere in the work of the executive, vice versa, right? And so forth and so forth. So the issue here is that each has its own competence. The legislature has its own competence and areas of jurisdiction, etc. The executive, the same, and so forth. So each is not supposed to interfere in the other. But here the Constitutional Court is actually saying that, be that as it may, the court has a duty to uphold the Constitution even when this requires it to intervene in the powers exercised by the legislature. So the attitude of the Constitutional Court in terms of this case is that even though we as the Constitutional Court are ordinarily we should not be invading into the competence of the legislature, of parliament, or the executive. We will do that if it is our view that the executive is acting unconstitutionally. We will not say that, no, because of separation of powers, we're going to keep quiet. I'm putting it in very simple terms so that you understand. So the Constitutional Court is saying that we will not say that, no, because it's the executive, we're not supposed to get involved. It is its area of competence. We will do so as a Constitutional Court so long as we are of the view that the executive is acting unconstitutionally, is not acting in terms of the Constitution. So this is the attitude of the Constitutional Court in relation to separation of powers. Is that clear so far?
Yes,
Yes.
It's fine if one person keeps saying yes. I just want to understand that whether we are clear or what, right? If I am speaking too fast, then you tell me. If I am using the language that you don't understand, you must tell me and say, okay, hold on, right? Did you understand so far what is the attitude of the Constitutional Court in relation to the separation of powers and courts? It's here, right? Understand this. This gives you a window into understanding separation of powers in relation to the judiciary. It tells you the attitude of the judiciary in relation to the notion of separation of powers. So the judiciary, the Constitutional Court, which is the highest court, the apex court in the land, is saying that we will not adhere to the classic notion of separation of powers when we think or we are of the view that there is an act or action by the executive or the legislature that imperils, that puts our constitution into disarray. But also it's quite important for you to understand the structure of the judiciary, how the judiciary in South Africa is structured. And this slide is basically to explain to you that you have the Constitutional Court as the apex court, the highest court in the land. It is followed in terms of judicial authority by the Supreme Court of Appeal, and that is followed by high courts or the High Court. In fact, it's important that we speak about there's only one High Court, but there are divisions of high courts. But when you talk about, for instance, when I say that I am an advocate of the Eastern Cape High Court, when I explain myself, I say that I am an advocate of the High Court of South Africa, because there's only one High Court. Because South Africa is a unitary state, you don't have different high courts with their own rules and so forth. That's why, for those who may be aware, for instance, you have what you call the uniform rules of court. So courts do not have their own rules. There's there are uniform rules of court that guide how the high courts function all over. Although each high court will have what is called its own practice directions, for instance, specifically tailor-made for that particular high court. But in terms of the rules, one rule for all of the high courts. So there's only one high court in the country. However, there are different divisions of the high court. So you have the high courts, and you have any high court of appeal that may be established by an act of parliament to hear appeals from any court of a status similar to the High Court of South Africa. You have magistrates court, and you also have other courts that may be established or are recognized by an act of parliament, including any court of a status similar to the High Court of South Africa or the, and you'll see some of them as we proceed. So these are the divisions of the High Court, not divisions of high courts. These are the divisions of the High Court, right? So you have the Eastern Cape Division, you have the Free State Division, the Gauteng, and already we can see that the divisions are in terms of provinces. So each and every province has a division of the High Court. Yeah, so that is how high courts are divided. So are structured. Sorry. So Apart from the courts referred to in the Constitution, there are also several specialist courts that are created by statute. And some of these courts are, for instance, the labor court, which deals with disputes between employers and employees. And you have the land claims court that resolve disputes that arise from land claims. You have the tax court that deals with the Income Tax Act, etc. For instance, with the labor court, to give you an example, you also have the labor appeal court, etc., etc. Right? You know, so this is for you broadly to understand that there are also other high courts, specialist high courts that deal with certain specific issues. Now let's go to constitutional jurisdiction of various courts. Right. But understand what jurisdiction is first. So jurisdiction in this sense refers to the power or competence of a court to hear and adjudicate on and to determine and dispose of a legal dispute. So the ability of a court to be able to hear a matter is called jurisdiction. So for a court to hear a matter, it must be enabled to do so. Right? So in a matter that deals with the Labor Relations Act, you can't go to the tax court. You can't take a labor matter to the land claims court and say no, but it's a high court also. Right? You must know where to go. You must go to the right place. But there are instances where there's concurrent jurisdiction. For instance, the High Court sometimes may have concurrent jurisdiction with the labor court on a particular matter. An employment contract, for instance. Someone may choose to go to the High Court to say that the employer fired me, in which the employer fired me was in breach of my contract. So you go to court, to the High Court, based on that. But someone may say that I think the manner in which my contract was terminated constitutes unfair labor practice, and therefore I'm going to go to the labor court. So in that sense, there's a sense in which there's concurrent jurisdiction between the High Court and the labor court. So it gets more complex, obviously, but for now, the point for you to understand is the structure of courts, that there are high courts and there are also specialist courts that have the same jurisdiction. There are also high courts, but they're specialist high courts. That's enough for you to know there, right? So when you consider the various jurisdictional issues, it's important to understand that the system provides for two distinct jurisdictional scenarios. First, in matters not raising any constitutional or related issue, and second, in matters raising constitutional issues. Now, you will see as we proceed that the issue of what constitutes constitutional and what does not constitute constitutional is quite a tricky one, right? I, for one, I disagree with the fact that there are constitutional issues and there are non-constitutional issues. Although courts have said that, but still I disagree. I believe that the moment you say that the Constitution is supreme and any act or conduct that is at variance or in contravention of the Constitution is invalid, then anything and everything is actually constitutional. There's always a relationship between anything and everything with the Constitution, because we are constitutional beings. So the fact that there are constitutional issues and non-constitutional issues, I find that a bit troubling. I don't agree with it, and it would be nice if you were to to one day get an an exempt question on that, to get your views on the constitutional and non-constitutional issues. I personally don't agree with that division. I think it's very artificial and pointless. It's redundant. That's my view. So you see now we're still talking about who can do what. Now that we've spoken about the division, I mean the hierarchy of courts, the structure of courts, the Constitutional Court, the Supreme Court of Appeal, and high courts, and so forth, right? Now we're dealing with the jurisdiction of the Constitutional Court. But before I even say that, it's important to understand the fact that usually how it goes, this hierarchy is not for the hell of it. It's there for a reason. So normally when you take your matter, let's say civil matter, usually normally you take your matter to the High Court, and the High Court finds against you, and then after that you go to the Supreme Court of Appeal to appeal the decision of the High Court, and the Supreme Court of Appeal dismisses your matter, and then you then go to sometimes the Constitutional Court, and then the Constitutional Court will listen to you. However, prior to 2013, there were matters that ended up at the Supreme Court of Appeal, and those were called non-constitutional matters. So they ended up at the Supreme Court of Appeal. You couldn't take them to the Constitutional Court because they were not constitutional matters. Hence, the view that until 2013, the Constitutional Court was a specialist court and not a court of general jurisdiction. However, in terms of the 17th Amendment Act, that has changed the Constitution, that has drastically changed the jurisdiction of the Constitutional Court. That situation doesn't apply anymore, right? So constitutional matters include I'm just explaining what constitutional matters include, that issues involving the interpretation, protection, or enforcement of the Constitution. And as I earlier said, that it is not always easy to distinguish between a constitutional matter and a non-constitutional matter, right? So before just ignore this slide for a second. Don't read it so that you can listen to me. Right. When the Constitution was called Act 108 of 1906, I see some people still refer to the Constitution as Act 108 of 1996. It is wrong to do that. The Constitution is not Act 108 of 1996. The Constitution is not an act in the true sense of the word. It's not statute in that way. That's why that was changed. How you cite the Constitution is simply to refer to it as the Constitution of South Africa 1996. That's how you do it. You don't say it's an act and so forth and so forth. You don't do that, but some people still do it. Just know that it is incorrect to refer to the Constitution as an act because of the manner it is how it was passed. Obviously, was using extraordinary methods. You know, so it was not like a normal act, and how an act gets passed, how an act becomes an act. For instance, from a bill, and then it becomes an act and so forth, right? So yes. Now, so here, basically, this slide is simply to say to you that, as I was indicating earlier on, about the constitutional and non-constitutional and the difficulty of actually separating the two, what is constitutional and what is not constitutional, for instance, is to say, for instance, in the pharmaceutical case, wherein the Constitutional Court says that I cannot accept this contention which treats the common law as a body of law separate and distinct from the Constitution. There are not two systems of law, each dealing with the same subject matter, each having similar requirements, each operating in its own field with its own high court. There is only one system of law. It is shaped by the Constitution, which is the supreme law, and all law, including the common law, derives its force from the Constitution and is subject to constitutional control. Now, having read this, you start seeing that it becomes very difficult to say that this is the common law and therefore the Constitution does not apply, because that is not true. All laws must comply with the Constitution, which means that if I'm challenging the common law, there's a sense in which actually I'm challenging the constitutionality of the common law. Hence, what I said earlier on, that I find separation between constitutional and non-constitutional matter senseless, actually. I appeared in court some time ago on an insolvency matter. And my opponent made a very passionate argument, and the judge agreed with him. I was also an advocate, said that because we were dealing with an insolvency matter, the Constitution does not apply. And I was like, where does this guy come from? How do you say that the Constitution is not applicable here? The Constitution is the supreme law of the country. It can't be that it's not applicable. There's only one system of law in this country. And that one system of law derives, the Constitution. The Constitution is what we have as law, simply because any other law that is at variance, that is in contravention with the Constitution, becomes invalid. So the idea that the Constitution and then law and so forth, it's quite nonsensical to say the least. So I that. Whoever is not has unmute, can they mute themselves? Thank you very, very much. Right. So this case, the pharmaceutical manufacturer's case, also tells you that, right? Look for it, and you have time. Yeah. So all legislation must be interpreted in line with the spirit, the purport and object of the Bill of Rights, and so forth. So that's basically, this here is a continuation of what I was saying. Where the common law deviates from the spirit, the purport, and objects of the Bill of Rights, the courts have an obligation to develop it by removing that deviation. This means that potentially any argument about the development of the common law or the interpretation of legislation could raise constitutional issues in an indirect manner. That's what I was saying earlier on. And here I don't agree with the authors when they say that indirect manner. I don't understand why they actually say indirectly, because I don't agree that there's any indirect thing. It's all direct. You know, so the idea of indirectly in constitutional issues in an indirect manner, I don't agree with that. I think it's incorrect. But anyway, it is their view, and I have my own view. Right. But you need to also understand the relationship between the common law and the Constitution. But before you understand the relationship between the common law and the Constitution, you must understand what the common law is. But before you understand what the common law is, you need to have a basic understanding of the history of the law of this country, right? So I'll leave that to you. I otherwise won't finish if I start with that issue or that debate, because I'm very passionate about it. I'm of the view, as someone said last week, that why did we continued with the laws that we inherited from apartheid? I'm of the view that we should have started afresh. That's my view. We would have dealt away with everything and started afresh. Anyway, so again, when it comes to the issue that we're talking about now, of course,